This conference will now be recorded.
There you are. So it will be uploaded to my YouTube channel, so long as there's not an interruption or a technical issue between now and the end of the session. So yeah, Section 8, the grounds. There are 17 grounds. A couple of them have subsections. So sections or ground 7 has ground 7A and ground 7B. And ground 14 has 14A and 14ZA. So there are actually 21 grounds in total. 10 of them are what we refer to as mandatory, and the other 11 what we refer to as discretionary, and we'll talk about that as we go through this particular session. I fully appreciate most of you will probably only have used the 3 most common grounds, which you'll all probably be aware of, which are grounds 8, 10, and 11, which apply to rent arrears. But obviously, the importance of understanding the other grounds can't be understated now, considering Section 21s at some stage will be abolished. So your landlord, if they wanted possession of a property and the tenant didn't want to leave, then obviously the 21 grounds under a Section 8 notice will become much more important. Just to let you know, if you don't have the ground wording, then let me know and I can send you a Word document which includes all the wordings for the grounds, because as you probably know, when you complete a Section 8 notice, you've got to include or copy word for word the wording from the Housing Act 1988 for the relevant grounds that you're using. So grounds 8, 10 and 11, which I said are going to be the most common grounds, hopefully you've got that wording. But if you want the wording for the other grounds, then let me know. Or if you're an MPO member, ask a dealer and she can send you a Word document with all the wordings for the grounds that will be applicable. Okay, so Section 8 comes from the Housing Act 1988. You'll find all the grounds in Schedule 2 of the Housing Act 1988, which I know sounds rather boring, but if you wanted to see where all the grounds come from, then if you just type Schedule 2 of the Housing Act 1988 into Google, it will pop up with all the 17 or 21 grounds, if that's the way you want to say it. So, as I said, the first 8, or the first 10, if you include the subsections of ground 7, are what we refer to as mandatory. So, if you prove it, the judge must give you possession. There is no discretion upon the judge in that sense. There shouldn't be any adjournments of the cases. It should be a relatively straightforward possession order in that sense, so long as you have all the evidence that you need to prove that you've served the relevant documents or evidence in relation to grounds 1 to 8. Grounds 1 to 5 are what they refer to as prior notices. Now, again, grounds 3, 4, and 5 aren't going to be that relevant to you, but grounds 1 and 2 may be and may become more important when Section 21s are abolished. So we're talking about grounds 1 and 2 in a bit more detail very shortly, but that's what we refer to as prior notice grounds. So before the tenancy starts, did you make the tenant aware that you may be seeking possession under grounds 1 to 5? It can be waived by a judge. So the further point down says can be waived by the judge if just an equitable to do so. So sometimes the judge will say, look, I'm not overly concerned that you haven't given the tenant prior notice that you are seeking possession under this ground, and therefore I'll waive it. So a lot will depend on the judge in that sense. But as always, it's always important to have your evidence that you've given prior notice to the tenant that you may be seeking possession at some stage under grounds 1 to 5. And as I said earlier, grounds 1 to 2 are going to be by far and away the most common for you as landlords. And at some stage, as I said, they will become even more important when you don't have the ability to serve Section 21. Because the majority of the grounds, as you probably know, aren't relevant because you just serve a Section 21. That's why you only really go down Section 8 because of rent arrears. But obviously, when we lose Section 21s, then the 17 grounds and their subsections will become much more important. That last point, or the second from last point, is you must state the wording in the grounds. Hence why I said earlier, if you don't have the wording for all the grounds, then let me know and I can send you my Word document for them all contained. Because if you don't do that, then there's a very good chance that your Section 21 notice will be invalidated, just to make you aware of that. Okay, so they're the bullet points in relation to I've just seen a spelling mistake, so my fault. So they are that's what applies to mandatory the mandatory grounds 1 to 8. The last point on there is that the judge could waive the requirement to serve notice, which is highly unlikely, but they could in exceptional circumstances. I've not seen it myself ever, but just to make you aware, the Housing Act 1988 does allow for that to happen on the odd occasion, but highly unlikely that would ever apply to you as a letting agent or landlord. Okay, let's go through the 17 grounds, just to give you an idea. So ground 1, which is my owner occupier ground. As I said, this is going to become actually quite important because I think this will be quite a commonly used ground after Section 21s are abolished. Now, I fully appreciate some of you are buy-to-let investment landlords, or quite a lot of you will be, and you will have a lot of properties, obviously, that you intend to that it's not going to be your main principal residence. So in a sense, ground 1 won't be that applicable to you, but it will be a bit applicable to quite a few landlords, especially those accidental landlords, which a lot of agents will have. So it's an owner occupier. You've got to give 2 months notice, and it can't expire before the end of the fixed term. Now, this is what we refer to as a prior notice one. As I said earlier, grounds 1 to 5 are prior. So in your agreement, it may say that you could seek possession under ground 1 of the Housing Act 1988, Schedule 2, as an owner occupier. So you're giving prior notice to the tenant before the tenancy starts that you may intend to seek possession under this ground. Now, in a sense, all landlords should do this. Why should they do it? Because your circumstances may change, that your buy-to-let investment actually may become, at some point in the future, your only residence. It might be somewhere you need to move into. So even though it may not be your main residence, or you may not intend it to be your main residence as a landlord, at some stage in the future, your circumstances may change that you may need to seek possession under ground 1 of a Section 8 notice. So it can't expire before the end of the fixed term. The green box is the important box in terms of the sort of terms and conditions. So one of the landlords lived in the property before the let as their main residence. So if you can prove that, that's all you need to prove. That could be electoral roll, that could be bank statements going to the house, that could be your name on council tax. All I can really say, and then you'll probably see this as I say going through all the grounds, we don't have many court cases on these because they've not been that used in the past, obviously. Because if you wanted possession of your property, you would just serve a Section 21 notice. So a lot of these grounds, even though they are in legislation, they've not really been tested in court. So I'm just going on what I believe would be the evidence I think a judge would accept as proof that you've lived there prior to the letting commencing. Now, I'm not saying I'm going to be completely right because some judges may not agree with me, but logically, that's the evidence I think would be acceptable by the courts. I fully accept we're going to have lots of court cases maybe in the future, which will very clearly define what is allowed as evidence and not. But I think electoral roll, council tax, bank statements being sent there. I'm trying to think of other things which maybe you can think of as I'm discussing this, but that would probably be sufficient enough for me to say that you could convince a judge that you lived there prior as your main residence. Now, I fully accept I might be completely wrong, but hopefully I am right in that sense in terms of the understanding of that particular ground. So if you can prove that, then the landlord or the judge would then need to give you possession under ground 1. And then the other part, which is in the more burnt orange box, is one of the landlords or their spouse intends to live in the property as their main residence. That's after possession has been sought. So if you can prove that there is a obligation or a requirement for you to live there as your main residence, then the judge again must give you possession. Now that's a little bit harder in terms of the evidence that may be required. It may be that you're renting at the moment yourself as the landlord and you need possession back because you're being evicted by your current landlord, which could happen. So that could be evidence there to say that you need it for you or your spouse. It could be that you are living abroad and you're coming back and you can show that's what's happening. Your job in Australia or Dubai has ended and you got to come back to the UK and that's where you want to move back to. That's your main residence. So accidental landlords is probably the most common there. because I know lots of agents will have a percentage of their portfolio who will be accidental landlords. It's exempt, or this is exempt if this doesn't apply if the landlord had bought the property with a tenant in situ, just to make you aware of this. So this only applies where the original tenancy was created between yourself and that particular tenant. So if you bought a tenant in situ, then ground one doesn't apply. So that's going to be a much more common setup or commonly used ground for landlords. So again, owner occupier, you've lived there prior to the let and you can prove that as your main residence, then the judge must give you possession, or you intend to live there after possession has been sought as your main residence as the landlord or your spouse, and then again you would be allowed possession under ground one. As I said, it's not happened. It's not, most landlords don't go through this route because they have options under section 21, but as I said earlier, this will become much more common when section 21s are eventually abolished. I need to be mindful of time, guys, as well, because I appreciate we've got 21 grounds to go through. So some of them I'll go through a lot quicker than others, purely from the fact that some of them won't really apply to you as a private sector landlord, but just touch on them very quickly so you understand the ground and why it's there. Ground two is the mortgage company. So again, this is what we refer to as a prior notice ground. As you might be aware, most mortgage companies will expect you to serve prior notice on the tenant and prove that you serve prior notice on the tenant that this property is subject to a mortgage, because ground two is where the mortgage companies may seek possession if the landlord has not been paying their mortgage correctly. So ground two can happen, and it's happened quite a number of times over the years, whereby the mortgage company said, look, the landlord's not been paying their mortgage, we are going to take possession of the property, and they serve notice on the current occupiers in situ. But ground two, again, prior notice, as in the landlord must make the tenant aware there is prior that this property is subject to a mortgage. Most mortgage companies will want to see evidence of that. In most cases, that will be contained within the tenancy agreement. Some mortgage companies will be quite awkward, and they will expect you to serve a separate notice to the tenant, to the tenancy, to prove that you've given the tenant or the person moving into the property very clear advance warning that this property is subject to a mortgage, and it may at some stage be sought in terms of possession because the landlord has refused to pay or has been unable to pay their mortgage. So again, that one's not going to really change with the abolition of section 21s. That's always been there. I've seen a couple of mortgage companies use this, but again, just to give you an idea of what we talk about under ground two. Ground three is our holiday let. Yes, our holiday lets. So again, this is prior notice. Again, I've never seen it used ever, but just to make you aware of it, if you were doing Airbnb, for example, which some of you do, then potentially you could get away with it here. So prior notice, 14 days notice to the tenant. This can be used during the fixed term, so you could actually end it earlier than the fixed term. The tenancy you create for that tenant can't be any longer than 8 months long, and it must have been let as a holiday let in the preceding 12 months to when you drew up that AST, or short hold tenancy. So again, unlikely that we'd ever use it, but again, if you had a holiday let, etc., then potentially you could seek possession under ground three of your section 8 notice. But again, there are certain criteria to that. Can't be longer than 8 months long in terms of the tenancy, and you must give evidence or prove evidence that you let the property in the preceding 12 months as a holiday let. So again, all about evidence. What evidence can you provide to convince a judge that you are entitled to possession? As I said, I've never ever seen anyone use ground free, but again, it might be a little bit more common, especially with Airbnb now, etc., where people are renting properties out in the summer, and again in the winter they're letting it under in a short hold. So it does give them the ability to seek possession on ground free. Ground four. Again, this isn't really relevant to you guys, but ground four is an educational let. So again, this is really whereby a landlord can seek possession where the property has again been let in the previous 12 months under an educational tenancy, if that's the right way of saying it. Again, I won't spend any time on this because it's not relevant to you, but again, that's what we refer to as an educational ground, ground 4, which isn't relevant to you as a private sector landlord, but again, just wanted to cover it in the training. Ground 5, again, unlikely, but it could potentially, as an agent, for example, they may deal with the churches. I know quite a few of my clients have churches as landlords. So again, ground 5 is a minister's home. Again, you need to give prior notice that you may seek possession under this particular ground, which obviously as a letting agent you will know. If it's owned by the church, there might be a good chance that the church may want the property back for religious purposes or employment purposes in terms of rehousing their flock, if that's the right way of saying it. So 2 months notice, can't expire before the end of the fixed term. The last point is obviously the most important one. The property is held for use by a minister of religion to perform their duties of their office and is required for occupation by a minister of religion. So again, the landlord would then need to have evidence that that's what they need it for. They've got a new member of staff or a new clergy person, and they need accommodation to be housed, etc. So again, if they were renting out on the private sector market, because the person that they currently employ has their own accommodation. If they get a new minister, which happens quite frequently, I think the person at my church changes every 2 years, then they have the ability to serve notice under this particular ground 5, and so long as they can prove that's what they are doing or what they need it for, then the judge must give possession. Ground 6. Again, social landlords. So I'm not going to bore you to death with this one. Social regeneration. So this is all about doing properties up, etc., 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 knocking things down, whatever they're going to be. So they do have the ability under that in terms of social landlords under ground 6. But again, not relevant to us as private landlords. So I won't spend any time on ground 6. Ground 7. Again, death of tenant is ground 7. So this is whereby person's died. There is either a will or no will, and the estate or the person that's entitled to the benefit from the estate potentially is not giving you possession of the property back. In most cases, reality dictates that they will do that because they don't want to be held liable for the rent moving forward. But potentially, you may be struggling to get hold of next of kin. You may have no next of kin completely, whatever it's going to be. So there may be issues whereby you need to serve notice under ground 7. As I said to you before, in most cases, next of kin will turn up, give you the property back, and you'll all move on. But on the odd occasion where it's maybe quite awkward to get next of kin, etc., and you don't have the ability to use section 21, obviously, then ground 7 could become more important. So death of tenant. So 2 months notice. Again, that notice can't expire before the end of the fixed term. And so long as you can prove that that person has passed away, etc., then you should be entitled to possession from the judge under ground 7. Just to make you aware, if the estate are paying rent to you, which is highly unlikely, but if they did, that doesn't create a new tenancy. This particular piece of legislation very clearly stipulates that. So accepting rent from the estate won't create a brand new tenancy in law. They're just basically following the obligations of the tenancy in relation to the deceased tenant. So in that sense, it's relatively straightforward. But as I said, that might become more important when we lose the ability to use a section 21 notice. As I said, in most cases, I'm sure most of you may have experienced the death of a tenant. In most cases, the next of kin will come back to you with a set of keys and you will end it by surrender. That's how it generally works in terms of death of tenant. But on the odd occasion, you may need to consider using ground 7 because you've got an awkward set of people who are managing the estate of this deceased tenant. Ground 7A is the antisocial behaviour ground. So just to let you know, there were 16 grounds under the Housing Act 1988. They added ground 17 in the Housing Act 1996. The subsections, so ground 7A, ground 7B, ground 14A, ground 14ZA were added after 1996. They were added, I think most of them were added in the 2010 sort of period. But just to give you an indication of that's what happens. So they've just added subsections. So Ground 7A is a subsection. I think this was added in 2016 off the top of my head, although I might be completely wrong in terms of that year. This is Ground 7A. So this is antisocial behaviour. So they do need to be convicted, just to make you aware of that. So it's slightly different to Ground 14 when we talk about Ground 14 in discretionary grounds. So antisocial behaviour, again, if it's a fixed term, you need to give at least 1 month's notice. If it's running periodic, again, you need to give at least 4 weeks notice, just to make you aware of that. Personally, I would always potentially just give 1 month's notice as a general rule, whether it's fixed or periodic, just to make sure that you don't fall foul of any ambiguity in terms of the courts. It must be in the locality, so just to make you aware of that. So if they committed an offence in a different town, then that would not be defined in the locality. Now, in the locality is quite a broad definition. So I would probably say in the local area. So, you know, if, for example, Nottingham, I would say if you committed an offence out, you know, in Nottingham, I would say it would need to be in a certain area within Nottingham. So I think Charlie's here. So, you know, if I've got a property in Beeston, I would need to commit the offence in Beeston, not in Radford, for example, because that would probably be a little bit too far away. So conviction required. It does need to be a serious offence. So they talk about, in terms of the legislation, a breach of an injunction or a criminal behaviour order, closure order for more than 48 hours, which I've actually had myself, sadly, in one of the properties that I managed. We had a crack house closure notice, which doesn't sound great, obviously. But yeah, we had one of those in our properties. The tenant was dealing drugs from the property. The police turned up and said, look, he's supplying crack cocaine to the local area. We have applied to the magistrates court for a crack house closure notice. And again, that would allow you then to seek possession under Ground 7A if one of your tenants had been served with notice under a closure notice, or your property had been served notice because they were dealing drugs from there. And the other one is the noise nuisance, in the sense that they had breached any noise nuisance injunction that had been served upon them. So not to play loud music, whatever it's going to be, and they continue to play loud music, then they obviously would be breaching that injunction. So therefore, you would be able to seek possession under Ground 7A. So again, an important ground if you have those types of setups, cannabis factories, potentially brothels, all that type of stuff would potentially fall under Ground 7A. I think under the Queen's speech, so to speak, when they do abolish Section 21s, because in the end, this should be quite quick. Serving notice, going to court is quite quick, but getting possession through the court is the hard part, or the long part. And I think that's potentially what the government are trying to change in relation to the abolishment of Section 21 notices, making that a lot quicker than it currently is, because that can still take quite a long time. It can take 3, 4, 5, 6 months to go through a Section 8 under Ground 7A. So I think that's what they're trying to provide as a offset against the abolishment of a Section 21 notice. So that's Ground 7A. The next one is Ground 7B. That come in with the Immigration Act 2016. So this is where you are made aware that someone has lost their right to rent. So it's an immigration offence. It's again 2 weeks notice under a Section 8 notice. You would have been served notice by the Home Office to say that you have in your midst a person who shouldn't be living there because they've lost their right to rent. Again, I don't know if anyone's ever received a notice from the Home Office in that sense, but if you do, to say that one person residing at the property is an illegal immigrant, so to speak, or has lost their right to rent, then you've got to serve notice under Ground 7B, given 2 weeks notice in relation to seeking possession of that property. Now, potentially, the judge, if one of the joint tenants has lost their right to rent, could, at possession proceedings, then just say we're going to remove the person who doesn't have the right to rent as a tenant from that tenancy. So the person that does have the right to rent will then get the tenancy in their sole name, and that the other person who doesn't have the right to rent will be removed. Now, I've not ever gone through this practically. I've not seen anyone go through it practically. I assume it's happened. I've not seen any case law on it, so I'm not too sure how quick it goes in relation to possession, or how quickly, or should I say, how costly it is going to be as a landlord to enforce this notice under a section 7, under a ground 7B. So if anyone has gone through it, please let me know, because again, from my experience or from my knowledge, it's all I learn off lots of other people. So I've never gone through ground 7B. So if anyone's had done it, then please let me know. I'd be interested to see how it has gone. And then the last one under a Section 8 notice is by far and away the most common. So Section 8 notice under ground 8, and that is our serious rent arrears ground. So again, 2 weeks notice. So at the time of service or at the court hearing, they must, if they have a weekly or fortnightly paid tenancy, they must be at least 8 weeks in arrears at the time of the court, at the time of service of the notice, and at the court hearing. Obviously, for a monthly rent, which is going to be the most common, they must be at least 2 months in arrears. Now, in terms of calculating 2 months in arrears, if my rent is due on the 1st of the month, if they haven't paid for the 1st of May and they haven't paid for the 1st of June, they are 2 months in arrears on the 2nd of June. So in that sense, you can serve a Section 8 notice on the 2nd of June. That is exactly when they fall 2 months in arrears. So if my rent's due on the 1st of the month, they haven't paid the 1st of May, they haven't paid the 1st of June, they are 2 months in arrears as of the 2nd of June. So in theory, you could serve a Section 8 notice on the 2nd of June. That's what Ground 8 allows you. If you have a quarterly paid tenancy, then they need to be 3 months in arrears, or they mustn't pay for 3 months. So if the rent's due on the 1st of January, they haven't paid on the 1st of Feb, they haven't paid on the 1st of March, and they haven't paid on the 1st of April, on the 2nd of April, because they're then 3 months in arrears for that quarterly payment, you can then serve your Section 8 notice in that sense. You basically have to wait till 3 months payment late, or the payment is late by 3 months, then you can serve a Section 8 notice for a quarterly paid tenancy. Now the yearly one's a little bit stranger, because the way the legislation is written, again, I've never ever seen anyone do a yearly arrear or have a yearly paid tenancy which is in arrears. So it says yearly, at least 3 months rent is more than 3 months in arrears. Well, that depends on whether you've worked out what a monthly payment is, because most people would put the annual rent is this. So from my perspective, it's not 100% clear what it means. So I assume it just says that you've got to break it down into monthly payments, and then as soon as they are 3 months in arrears or their payments late by 3 months, then you can serve a notice under Ground 8. But again, practically, I've never done it, so I'm not 100% sure whether or not that is 100% correct. I assume it probably is. I'm 99% sure. So the yearly pay would need to be 3 months in arrears before you can serve your Section 8 notice. I assume that's what they mean by the last bullet point, but just to clarify, there is a little bit of ambiguity in that sense. So they are the first 8 grounds, or the first, including the subsections, the first 10 grounds which fall under mandatory possession. So long as you prove it, then the judge must give you possession. There is no discretion of the judge. Then we have what we refer to as the discretionary grounds, and there are basically, that's the next 9 or next 11 if you include the 2 subsections. So again, it must be reasonable to grant possession. Now, as a general rule, as you probably all know, I would never go under discretionary grounds only. I would normally serve a Section 21 notice, because in theory, you are guaranteed to get possession. But as always, if you're losing Section 21, then the discretionary grounds are going to become much more important. The problem you've got, and I was speaking to a person, he's asking me about possession and courts. I've been to about 10 court hearings in the last 3 months, and each and every time the judge and the way the courts work has been slightly different. So it's really hard to say what is the benchmark in relation to Section 8 notices, especially under the discretionary grounds. So you always have to take everything I say and you do as landlords or letting agents with a pinch of salt, because what you think one judge may accept may be completely different to what another judge would accept. And that is what we're always all going to have to accept when things go through court. Every judge and every court is going to be slightly different based on the circumstances, even even based on the even based on how the judge feels on that particular day. I've had those decisions where you get one decision by one judge one day and it's slightly different to a decision by the same judge in a different courtroom on a different day. So a lot will depend on how the judge is feeling on that day. So discretionary grounds must be reasonable to grant possession. They have a wide range of powers for adjournment. So you might get a lot more adjournments on this, as in suspensions of possession orders. The tenant can stay there so long as they do this, this, and this. So as I said to you before, discretionary grounds are something which I generally don't go on if I'm relying on them only. But obviously under Section 21, they are, or when the Section 21s do get abolished, they are going to become much more important. So let's go through the 9 discretionary grounds plus the 2 subsections. So ground 9 is, again, this can't be used during the fixed term. So this isn't blaming the tenant for anything. This is about alternative accommodation. So again, unlikely that you will ever use it, but if you wanted to because you were refurbishing one property and you wanted to move the tenant into another property that you had, which is obviously doable, and the tenant wasn't agreeing to it, you potentially could seek possession under ground 9. You still need to house the tenant, but you just house them in a different property. But as you can see at the very bottom, and again, I haven't seen much court case law on this, the legislation and the guidance talks about it needs to be relatively similar in terms of location and size and description to the original property that they were renting. So they talk about schools and work. How far is it from those particular establishments? Size and furnishings, are they of similar quality? If one property had a garden and the one that you're trying to move them to doesn't have a garden, there's a great likelihood that you won't be able to get possession because the judge would say it's not similar to what they were originally renting. So again, just be wary of that. But ground 9 is, again, a very uncommon ground, but it might be a ground which becomes much more common when Section 21s get abolished. And the landlord would be liable for the removal costs of that tenant, or the moving obviously from one property to the other. So ground 9 is our discretionary ground. Again, I'll be very surprised if you ever get a judge awarding you possession under ground 9. So it's not something I would say would be that I wouldn't advise to go on that ground only. But again, as I said, it may become much more common when Section 21s get abolished. Ground 10 and 11 are to do with the rent arrears. So they build in, you always build them in with ground 8. But so ground 10 is some arrears, again, 2 weeks notice. They talk about, and there have been a couple of court cases where if you have a housing benefit tenant, and the reason why they are in arrears, not maybe 2 months in arrears, but the reason why they're in arrears is they're waiting for a housing benefit claim, it's highly likely that you won't be able to get possession under ground 10. Even though there's arrears, the judge will say it's not reasonable for me to provide possession on that basis. So just be wary of that if you have housing benefit tenants. Ground 10 and ground 11, well, potentially ground 10, shall I say, it's not going to be that fruitful if you are going to seek possession under Section 8. Ground 10, utility arrears can be classed as rent. So if you include, or if you have a separate obligation to pay utilities, maybe in shared housing, whatever it's going to be, then that is deemed to be rent for the purposes of ground 10, so arrears, which again may become much more common, especially with the increase in utility prices. The judge at the bottom part will take into account your process. They will take into account the tenant's payment history. So if they've been a gold star tenant for 3 years and then over the last 3 or 4 months they've got into arrears, then the judge will take that into account and say, actually, I don't think you can get possession on that basis. They've been a good tenant. you may be able to get possession under ground ground 8, but obviously that's going to be at least 2 months in arrears. And then the last one is the pre-action protocol. So whenever you're chasing tenants for rent arrears, you've got to have you can't just go straight to court. You can't go, well, you're 1 week late, I'm going to serve you a 2 weeks notice, or you owe £200. The judge will want to see that you've tried to deal with this in a fair manner before you started court proceedings. So as always with rent arrears, they always take into account their pre-action protocol. So that would probably be 2 or 3 warning letters in terms of rent arrears, probably a couple of months before you start serving Section 8s and going down that particular route. So they will always take that into account when you're dealing with rent arrears. Again, some judges could throw it out because you've not followed the pre-action protocol process. Ground 11 is late payment or persistent delay in rent payment. Again, they can actually be in no arrears, but you have a long history of them paying you late. Now, are you going to get possession on ground 11? They don't owe you any money, but they always pay you 3 weeks late? Probably not, I would say. But obviously it works well with grounds 8 and 10, should the tenant be £200 worth of rent arrears, but they were 2 months in arrears when you served to Section 8. They've paid it down slightly, but they've always been late. You persistently have to chase them. Then there's a small chance, a very small chance, that you may get possession under grounds 10 and 11 combined. But again, I don't know if anyone's ever got possession just on grounds 10 and 11. But yeah, if you have, then please let me know. In most cases, well, I've never seen it in my lifetime. I've been to plenty of courts in that sense. So I'll be interested to know if any of you have possession or got possession under grounds 10 and 11 only. Ground 12 is a very generic ground. As it says on the particular screen, it's any breach of tenancy other than rent. Which basically means, have they breached the term or a clause within your tenancy? The only real issue to be mindful of there is fairness. Is it fair, the clause that you're trying to impose upon the tenant? Because if it's not, then the judge will say, well, I would not expect any tenant to comply with that clause because it's not fair upon them. So cutting the grass once a month, which I've had one landlord in my lifetime say, I would say that's unfair. Even though the tenants agreed to it, you couldn't seek possession for that under that particular clause. Because I think lots of people would say that's not real, that's not a realistic obligation that the tenant should be allowed to be evicted for. Not keep pets. I think as a general rule, that particular clause could be deemed to be unfair because there may be lots of genuine reasons as to why a tenant may be able to keep pets. For those that have been on my courses before, I'm sure you can tell me a few of those situations where you are allowed to keep pets. So again, having a pet when you shouldn't, or where the tenancy doesn't allow you to have a pet, potentially could be deemed to be unfair. Not allowing access for selling properties. I know that's come up quite a lot. I think you might struggle to get possession on that ground, under ground 12, should I say. I've seen a few people have real issues with that, but I would say most judges will probably be much more tenant friendly on that. And then the last one is cleanliness. It's not clean. Well, cleanliness is very subjective. What's clean to one person may not be clean to another. So again, all those things come into account when you're dealing with breach of tenancy in relation to Section 8. Ground 13 is to do with property condition. So very similar to grounds 12 in terms of breach of tenancy, and maybe ground 15 when we talk about furniture damage. So again, property condition and common parts. It includes the common parts as well. So you need to be mindful of that. So if you have a flat in a block, it's not only the flat it covers, it also covers the common areas. So if you're getting lots of complaints from the block manager about the condition of the hallway because it was being damaged by the tenant, then you could seek possession under ground 13. But again, it's all about evidence. So again, 2 weeks notice. They're breaching the terms of their tenancy potentially. It applies to the tenant or any occupier, especially if the tenant hasn't taken reasonable steps to get rid of that occupier. So just to make you aware of that. So that's ground 13, property condition. It's deteriorating, or the common areas are deteriorating because of the tenant or any other person that's living at the property under the control of the tenant. So stairwells, car park areas which they're just dumping rubbish in there, bin areas where they're dumping mattresses and all that particular stuff, or they're not using the bin areas correctly, then potentially you could seek possession under ground 13. Now, it's highly likely that the judge will say, yep, you've breached ground 13. I can see that you're not keeping the property in the condition it should be, but it's highly likely that they would suspend that order based on the tenant improving the condition of the property before a next inspection, for argument's sake. So that's how I would say most judges would work in relation to property condition. But again, I don't know if anyone's ever had possession given under ground 13, but I would certainly say it would probably be suspended in the majority of cases, pending the tenant rectifying what they had done wrong in the first place. Ground 14 is our nuisance notice. So just to make you aware, there is no notice period required. You still need to serve notice, but you could go straight to court that afternoon or an hour after you had served notice. However, it's broken down into two parts. So the first part is where they are guilty of. So they don't need to be convicted, but you need to provide evidence that they've caused nuisance or annoyance to people in the locality. So again, that's quite wide-ranging in its definition. So anyone in the local area or in the local postcode is probably a better way of saying it, or anyone that's working on behalf of you as a landlord or the agent. So contractors, those types of scenarios. So potentially, you can seek possession under those, them being guilty of annoying or causing annoyance to a nuisance, let's say, to people in the locality, next door neighbours, or someone that's working on behalf of the landlord or the agent. But again, that's where the evidence is so crucial in relation to that part of ground 14. The second part of ground 14 is where they've been convicted. So they've been convicted through the courts in relation to using the premises for illegal or moral purposes, drug dealing, cannabis factory, etc. Then you can seek possession under ground 14. An indictable offence. So that could be a serious offence. So that needs to be tried. The legislation says it needs to be tried by a jury. So they need to have maybe, I'm sure there's lots of things that you could say. Getting, example, a speeding ticket is not going to be done by a jury, but manslaughter or sexual assault or those types of things would be done by a jury. So in that sense, it would need to be quite a serious offence for you to be able to seek possession under ground 14. So that's our nuisance and conviction ground 14, and there is no notice period required for that, but obviously you do need to collate all the evidence to be able to convince a judge that you are entitled to possession under ground 14. So it might take you quite a lot of time, a couple of months, to collate that evidence, then to be able to serve notice under ground 14. Ground 14A, and I won't spend any time on this because it's not relevant to you. This is about domestic violence. So this is where obviously they've a couple of or people that are deemed to be coupled, a couple have moved into a property. One's committed domestic violence against the other. One of them's moved out of the property. The registered housing provider can seek possession under ground 14A, and that's domestic violence. But that only applies to social housing providers, not you as private sector landlords. 14ZA is our rioting ground. So again, hopefully you'll never need to use this, but if the occupier, or should I say the tenant, has been convicted of rioting, then you can seek possession under ground 14ZA. Obviously, this came out after the London riots back in 2011, just before the London Olympics. Just to make you aware, in terms of, I had to go and read up about what they mean by the definition of rioting. So their definition of rioting is 12 or more people, public or private areas, so whether it's outside or inside your home, they've got to be deemed to have threatened or used violence against others or property. So there needs to be 12 or more, public or private areas, and convicted of threatening or using violence against others or property. And that, in theory, is deemed to be rioting, and therefore you could seek possession under the ground 14ZA. Hopefully you'll never need to use it, even now or even in the future. but it's there for you. If we ever have an issue with rioting, again, you could seek possession under ground 14 ZA. A lot of social housing providers used it after the Olympics, the London riots. They sought possession of a lot of properties where people were convicted of rioting. I think even someone who was convicted of looting was deemed to have committed rioting offences and therefore was evicted from their social housing. Back in the day, that was obviously then trying to prevent or show people that doing that obviously come with serious consequences for them. Ground 15 is deterioration of furniture. So this is the landlord's furniture, obviously. And again, this fits into ground 13, which is the property condition. So ground 13 and ground 15 probably work in tandem. But again, 2 weeks notice. And again, it's all about providing evidence that the tenant is destroying or has caused deterioration to the furniture during the tenancy itself. So that's ground 15. Again, as I said, it works quite well or in tandem with ground 13, 2 weeks notice there as well. Ground 16 is a former employee. So if you gave a tenant an assured short hold because it was tied to their work or whatever it's going to be, then potentially you could seek possession under ground 16. Can't use it during the fixed term, or you can't, it can't expire before the end of the fixed term. And you've got to again prove that that's the reason why you were seeking possession. So I don't know if there's anyone, again, it's not going to be that common, but potentially when you're losing the use of section 21, then potentially it might be the odd occasion that you may need to use it. It's not applicable to agricultural tenancies or lets, which is one of the most common reasons why people have accommodation tied with their employment. So I'm just trying to think. So school caretaker, person in a pub that's renting a property next door. I'm sure there are other examples of the reason why you gave a tenant a tenancy because it's tied to their employment. So that's ground 16. It can only be, as I say, it's current or previous landlords, let's say, they can use it in relation to ground 16. And then ground 17 is the last one you'll be glad to hear. Again, this is what we refer to as false statement. The tenants lied to you as part of their application, or they got someone to lie on their behalf. So they got their previous landlord to lie, or a personal referee to lie, whatever it's going to be. So in that sense, you can use it even if it's someone else who's lied to you, so long as you can prove that they were acting because of the tenants or the applicant's instructions. So again, false statement is quite a powerful ground. I've seen a couple of people use it where they've been given false information about their work in terms of wage slips, or they got the previous landlord's reference was not genuine. So I've actually seen a couple of courts be quite hard on that in relation to the tenant, because very clearly the landlord has been hoodwinked into giving a tenancy to that particular person. So ground 17, which I've seen used in reality a couple of times, is actually quite a powerful ground. So if you have that setup where you've been hoodwinked into giving a tenancy and you wouldn't have done so in the first place because of the false information that you've been given, then ground 17 is a really powerful ground. But again, all that evidence, the judge will want to see the evidence that they have done that, and you can therefore you need a bit more investigational powers as a landlord or agent. So they are the 17 grounds plus the 4 subsections, so 21 in total in relation to a Section 8 notice. As I said, grounds 8, 10 and 11 are going to be the most common at the moment because that's the way you would do in terms of rent arrears. All the other grounds, you generally go under Section 21 because that's the easiest way of doing it. But as I said earlier, I know you know, and I keep repeating it, you may not be able to use Section 21s at some stage in the future. So these 17 grounds will become much more important in relation to protecting yourself as a landlord and also protecting your landlord client. And understanding the 17 grounds is going to become much more important as well. As you know, they may add other grounds in there to give the landlord the ability to sell a property. Again, evidence required that they are selling it, etc., etc. We don't have the finer details on that, and hopefully that may come out in the next couple of years. But I assume they may add that particular ground. So we might have ground, ground 1A or ground 1B or whatever it's going to be in relation to a Section 8 notice. So very quickly in terms of a summary, because I know I'm slightly over time. Section 8 grounds to be strengthened at some point, which I've just mentioned. Just be aware, under Section 8, there's always a court hearing. because you've got to prove to the judge that you are entitled to possession. So under Section 21, the majority of cases don't go through court, as in a court hearing. Most of those are done without the need for a court hearing. But Section 8 is most definitely a court hearing. They may change it, I don't know, but very unlikely that they will do. That means, from a landlord perspective, they would have to have a very good understanding of the legal system. Otherwise, they're going to have to employ a solicitor, and they become very expensive. So landlords, in particular, will need to become much more educated on how Section 8s work, all the evidence that's required to have a successful Section 8 claim, and also understand how the courts work. I may do a webinar on it in the future. They call it the civil procedure rules. So the civil procedure rules are basically how the courts work, what forms you send in, the timescales, what you need to do in terms of notifying the courts and the tenants. So that's your obligation as a landlord to understand that. And if you don't understand it and you don't provide the relevant information to include witness statements, etc., then potentially any claim can be thrown out. So Section 8 will put a lot more emphasis upon a landlord and an agent to understand how the court systems work. You can't just plead ignorance, because in the end it's your responsibility as a landlord and the agent to understand how the courts do work. As I said, the last part, really, the one in sort of the pinky purpley colours on the right hand side, it can be adjourned numerous times. Where you have court hearings, tenants are quite clever, and I've seen a couple of tenants able to use hospital appointments, COVID, all those things adjourn court hearings, and can lengthen a normal court process from 3 months to a couple of years quite quickly. So just be wary of that as well. So when we talk about the abolishment of Section 21s, Section 8s are going to become much more complicated and potentially increase the length of time it takes to get possession of the property, unless the government, whoever's in charge, invests quite heavily in the courts, and has a very clear timeline in terms of what tenants can or can't do. So it'll be interesting to see how it works, purely from a complete nosiness perspective. But that's a very, very quick overrun in terms of Section 8 notices and the 17 grounds. Obviously, next week, I will be going through how to complete a Section 8 notice. I appreciate that's gone through quite quickly, but it is 53 minutes past 11. So are there any questions, or is anyone still awake? Is probably the easiest way of asking it. Everyone's on mute, so I don't see any typed questions. So I'm hoping everyone sort of understood that. But that's a very, very quick run through. As I said, if you need me to send you the wording for the 17 grounds, then I'm more than happy to do that. Just send me an email and I will do that for you. I have it on a Word doc, so I can send that to you quite easily, because obviously that's going to be quite important for next week as well, when we are going through how to complete a Section 8 notice. No comments or texts, so I assume everyone's okay to a certain extent. Thanks, Stephen. Just make sure everyone's alive. I don't want to be talking to myself for the last 53 minutes, which I've probably done. Anyway, I will leave you all in peace. I can't remember, George, whether you're an Arsenal. I think you're an Arsenal fan, aren't you? So I won't wish you any good luck. I wish James good luck, and myself. Hopefully Spurs will smash you to pieces tomorrow. Anyway, I wish you all well. The recording will go up onto my YouTube website today, or later on today, in that sense. But I wish you all well and have a good rest of the day, although it's pouring down with rain down here, so I assume you won't. Okay, thanks guys.